If you watch a contortionist twist their body into these unbelievable shapes, it can kind of blow your mind. You're marveled that the human body could bend that way. Well, taking a look at the case of Jessup versus the city of Fresno, well, that showed a level of linguistic and judicial contortions that not only baffles the mind, but crushes the soul. So we'll take a closer look at that next on the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from a long through line of everyday Americans.
Well, hello there, everyday Americans. Paul Engel here with the Constitution, where we read and study the Constitution and we teach the rising generation to be free. I'm glad you could join me. As always, I'm going to point you to the website, constitutionstudy.com, so you can find out everything I'm doing here at the Constitution Study. You can help those who help share this information. People that help make these broadcasts happen, whether it's the band Rebel North, let me use their music, constitutional grassroots movements, Restore the Intent, Conversations on the Culture that share this, and others like you that take these messages, use them to educate themselves, and then share it with others. All this is made possible by people like you sharing the news of what's going on. You can help. Head over to the website. You can sign up for the mailing list. I send out a newsletter once a month, let you know what's going on with the Constitution Study. You can also get these videos, the audio, the web articles delivered to your inbox if you'd prefer to get the information that way. I have had some issues with my website being blocked, but I think we've got those pretty much under control. Most of all, I want to encourage you to learn to teach those around you, especially the next generation, because if we don't, this idea of liberty and freedom we will watch to continue to die. And a perfect example is this case of Jessup versus the city of Fresno. As part of an investigation, officers of the city of Fresno executed a warrant to seize monies, negotiable instruments, securities, or other things of value from 3 different properties owned by Micah Jessup and Britannis Azijan. I'm sorry, I must be mispronouncing those names. We'll call them the appellants. It'll be easier. Now, the officers were ordered by the court to retain the property they seized in their custody. Following the search and seizure, the officers gave the appellants an inventory stating that they had seized approximately $50,000 from their properties. However, the appellants claimed that the officers actually seized $150,000 in cash and another $125,000 worth of rare coins. They then sued the city of Fresno and the officers, Carrick, Kumagai, Kurt Christian, and Thomas Cantu, under 42 U.S.C. 1983. It's the law that allows people to sue based on a violation of the Constitution. In this case, a violation of their 4th and 14th Amendment protected rights. Now, the officers and of the city of Fresno moved for a summary judgment on the basis of qualified immunity. The case was heard in the Eastern District of California, which found in the favor of the officers. It was then appealed to a panel of the Ninth Circuit Court of Appeals, which upheld the lower court ruling. However, it is the reasoning behind these opinions that really disturbs me. I am not sure what reasoning the attorney for the appellants used to decide to sue in federal court. Now, it could be because they were claiming a violation of equity under the U.S. Constitution, in which case federal courts would have jurisdiction. Article 3, Section 2 says, "The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority." It could be their attorney thought they stood a better chance in federal court than one closer to the city of Fresno. For whatever reason, this case and the resulting trashing of justice is in the federal courts. Now, both courts found that the officers of the city of Fresno were entitled to qualified immunity because, quote, "At the time of the incident, there was no clearly established law holding that officers violate the 4th or 14th Amendment when they steal property that is seized pursuant to a warrant." Now, reading this opinion from the Ninth Circuit, I found several failures of the judicial system to protect the rights of all involved, or in other words, to follow due process. But just the idea that there's not established law that you violate a person's 4th or 14th Amendment right when you steal from them while executing a warrant should make your head explode. The idea of qualified immunity is not inherently a bad one, but it does have some issues. Now, quoted in the opinion from the Ninth Circuit is Pearson versus Callahan, which says, "The doctrine of qualified immunity protects government officials from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known." If a government official unknowingly or unintentionally violates someone's rights, they are granted a level of immunity, qualified immunity. Now, since the Constitution sets out restrictions on government, only government agents can violate your constitutionally protected rights. Of course, then there are statutory rights, in which the government often restricts the actions of people. The legality of these actions are a discussion for another episode. The issue I have with qualified immunity is, why do only government officials receive such protection? We've all heard that ignorance of the law is no excuse, apparently unless you're a government official. See, if a government officer receives immunity for violations a reasonable person would not have known about, why shouldn't everyone else? When did we give governments the authority to create unequal protections under the law? Now let's look at the issues of the case. The Fourth Amendment to the Constitution says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizures shall not be violated. See, among other things, the Fourth Amendment protects your right to be secure in your person and property against unreasonable search and seizures. Now, the officers had a warrant, which I believe included where they could search and what they could seize. But the question remains, if it is reasonable, if a reasonable person would believe a government official seizing property had the authority to pocket part of it. Remember, the definition of qualified immunity is something a reasonable person would not know. Well, is it reasonable to expect your property to be stolen during a seizure? The city officers insist that because the appellant seized assets pursuant to a valid warrant, there was no Fourth Amendment violation. Appellants, on the other hand, argue that the city officers' alleged theft was an unreasonable seizure under a violation of the Fourth Amendment. And that's the point. The city says, hey, we had a warrant to seize the material. But the appellants are saying, yeah, but these people stole. At least we allege they stole. Yes, the Fourth Amendment defines the requirements for a warrant, but it is also meant to protect us from unreasonable searches and seizures, warrant or not. Is the court really saying that it is okay for government officials to steal private property as part of a seizure? And what about the 14th Amendment? No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. We can clearly see how officers of the state, of which the city of Fresno is a part, attempted to deprive the appellants of a significant amount of property without due process of law. If the appellants were found not guilty, they would expect to have their property returned. Now, if what was actually seized was over $250,000 worth of property, but they were only returned $50,000 worth of property, that's a significant value difference. That would be property they would have been taken without due process of law. That's 1/4 of what they allege was actually seized. Is the court really saying that a warrant to seize property is also a warrant to steal? And that just because they had a warrant, these officers are protected from returning the property they are alleged to have stolen if they're found guilty. That's the big thing, if they're found guilty. Now, the part of the story that truly disturbs me is not that government officers have stolen property. The fact that people steal is reprehensible, but not surprising. See, I also find that the court's opinions are wrong. But that isn't new. I mean, that's not what made my head explode. I deal with courts getting it wrong all the time. It was the reasoning the court used to come up with their opinion that got me mad. And it can be summed up in 2 sentences from the case's summary. Quote, The panel held that it did not decide whether the city officers violated the Constitution. The panel determined that at the time of the incident, there was no clearly established law holding that officers violate the 4th or 14th Amendment when they steal property that is seized pursuant to a warrant. Yeah, finish putting the duct tape on your head. Let me get this straight. Both the district and circuit courts of the United States of America said they didn't decide that the appellant's rights were violated. No. They didn't even consider if a reasonable person would think that stealing money during a seizure was reasonable. They didn't even consider that. The city of Fresno thought the stealing the accused money was due process. They didn't even consider that. How could these judges come to such a twisted conclusion? Likely because they never even got that far. Do you know why? They determined that the officers received immunity before they even got to the question of the rights of the appellant. Quote, to determine whether a defendant violated an individual's clearly established rights, we must determine whether the state of the law at the time of the incident provided fair warning to the defendant that his or her conduct was unconstitutional. Now, first of all, the sentence actually contradicts itself. If the right is clearly established, then it's part of the law. The right for your seizure to be reasonable and for your property to be protected by due process are both clearly established by the Constitution of the United States of America, which, according to Article 6, is not only the supreme law of the land, but also requires those officers, in fact, legislative, executive, and judicial officers, to swear or affirm to support that Constitution upon taking office. That means not only the officers involved in the seizure, but all the officers of the city of Fresno had to swear or affirm they would support the Constitution before they could take office. And in fact, all the justices of the district court and the circuit court had to swear or affirm they would support the Constitution, including the 4th and 14th Amendment, before they could assume their office. How can there be a question if a right is violated if that right is clearly established? The answer comes from the quote-unquote law the court is referring to. Quote, we do not require a case directly on point, but existing precedent must have placed the statutory or constitutional question beyond debate. In other words, the constitutions that the judges swore or affirmed to support is not sufficient law for them. See, when they refer to the state of the law, they mean the state of judicial opinion about the law, what in legal circles is called case law. So the idea that a reasonable person would find theft of property an unreasonable seizure doesn't matter. The idea that a government official stealing a person's property is not a violation of their due process protection doesn't even get examined. All because they do not have an opinion of another judge to tell them to do what they swore to do when they took office, to support the Constitution of the United States of America. Because some priests in black robes declared that the failure to return seized property is reasonable while some others don't, well, that means these men do not get justice. Because one court's opinion said failure to return seized property is not depriving them of it, how they got there I have no idea, this court denies the appellants even their day in court. Now, is your head exploding yet? This is a perfect example of the denial of justice due to the court's obsession with legislating via case law. If another court hasn't blessed what their law says, i.e., if there isn't precedent, it doesn't matter. You can read more about case law in my article, The Myth of Case Law, and I'll put a link in the description below. Now, if you want to know why I say we don't have a justice system, we have just a system, it's because of cases like this. As William Penn said, to delay justice is injustice. Or, as you may have heard it paraphrased, justice delayed is justice denied. These men have been denied justice in their case. And we have all been denied justice by a judicial branch that has subverted the legislative system. They have perverted their judicial power into the power to overturn the law of the people, the U.S. Constitution, and the people's agents in Congress. They have elevated themselves to the position of legislature by defining laws not by what Congress has passed, but what their fellow judges have opined from the bench. They've elevated themselves to oligarch and king. This is the very definition of bad behavior, yet none of us is pressing our agents in Congress to do their jobs and protect the rights being trashed by an out-of-control judicial branch. And everyone seems to forget that 10 of the 27 grievances we used to declare independence from Great Britain involved an overreaching or unaccountable judiciary. The Declaration of Independence says that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it and to institute new government. It is time we, the people, order our agents in Congress to hold the judiciary accountable for their bad behavior. These judges swore or affirmed an oath to support the Constitution. If they will not abide by their oath, if they insist on behaving badly, they must be removed. And the responsibility for making sure that happens falls in our laps. Will we do our jobs? Or will we let justice die in the shadow of judicial opinion? So tell me what you think. Put your comments below. Let me know what you think. Is this as egregious a violation of justice as I have put forth? Is the idea that violations of the Fourth Amendment and 14th Amendment are not considered viable until a court blesses them? Can government officials get away with violating them because some court somewhere hasn't said it's okay? Can your justice be denied just because a judge says, yeah, there's no real reason why a government official thought theft was constitutional, just because they had a warrant? And again, I don't mean seizing property and officially holding it as evidence in a trial. I am talking about stealing it for private purposes. If any one of us pulled the same type of shenanigans, we would be locked up. Why can these appellants not get a chance to get their money back if they prove that the money was stolen by government officials acting as government officials at the time? If these officers are found guilty, they should go to jail, but they should also pay reparations to the people they stole from. And no court should have the power to say, nah, we don't think we think they should be protected from illegal activity because, well, no reasonable person would think stealing is an unreasonable seizure. Give me a break. This is ridiculous. This is the type of nonsense we started a war over 235 years ago. When are we going to say enough is enough? When are we going to start saying these grievances against the court are too much and go to our elected officials, our agents, the members of the House of Representatives that have the power to impeach these people and saying, you must remove these people or we will remove you? Because if we don't, we'll get more nonsense like this. And I have more nonsense like this in other episodes. So head over to the website, constitutionstudy.com, check out some of the related episodes. See what I mean when I say this type of stuff goes on and on and on and on because we ultimately let it happen because we let our agents off the hook. And if we want to get a judicial system that does its job, that remains under control, then we have to kick our representatives in the butts and remind them to do their job, or we'll find someone who do. So hopefully it pissed you off a little bit. Hopefully it got you engaged. Hopefully you've got your phone ready to call your representative. And hopefully you'll come back the next time and we'll talk more on the Constitution Study. Have a great day.
Every day